Very good. All right, what we're going to talk about, how many people are here from outside of Texas? Everybody. Okay. Well, yeah, yeah, probably would have been better. You can use this information as a general toolkit as far as what you should be thinking about in your state with your loved one. And I'll skip over a lot of the law that deals with Texas, but in general, you need to be thinking about guardianships, have wills, be sure your kids are on the Medicaid waiver programs in your state, and things of that nature, and we'll go from there. All right, again, this is a lot about on Texas, and each individual is different. So take a lot of this as a general information session. I'm not a typical attorney. This is my second career. I was a geologist for 35 years and went back to law school at night, and about 18 years ago, and still worked as a geologist until 2015. And then I was laid off because I was making too much money and they could hire 3 kids for what they're paying me. So open up my practice, especially with my daughter. A lot of folks would probably say, why don't you go in oil and gas law? Well, I went into what I enjoy doing. I enjoy working with families with kids with special needs and doing everything. And a lot of the presentation is exactly what we've done for our daughter. So we know it works, and that's what I do in my practice. But the special needs toolkit, it's a combination of everything. Everything to the left, our guardianship, that's when our kids turn 18. Unfortunately, they're adults. In Texas, they're adults. There's a few states that go 19. And in Texas, you can't call the doctor or start doing what you were doing prior to age 18. Texas Children's going to cut off your internet access to your loved one, and you'll have to start it back up once they turn 18 or get guardianship. So that's a big issue. Be sure if they're going to get SSI and Medicaid in the future, or if they're getting it now, you can only have $2,000 in assets. So we want to set up with families where, in my situation, everything goes I guess I need to be in front of this. Goes to my wife first, and then if we both die in an accident, we have everything going to my daughter's special needs trust, and I'll tell you why that's needed. Be sure you have proper estate planning because your loved one's going to need help for the rest of their lives, so take that up. We'll talk a little bit about SSI and Medicaid. Sign up for the Medicaid waiver list. Texas, unfortunately, is one of the states that are bottom of the list, 49 out of 50 on the way we treat our loved ones with special needs or disabilities. My daughter just got a waiver program, HCS. We'll tell you what that means later, after waiting 17 years. So you need to hopefully your kids are already on those waiting lists in the states that you're on. We'll talk a little bit about the letter of intent, your support team. You're here. That's the one good thing that you're doing is talking with other parents about your child's particular situation. My wife and daughter's at a resource fair. I'm fixing to go to it after this, but go to your local resource fairs at your schools or some of the situations are putting in, because there's a lot of good vendors there. And you'll get a lot of information on the help that you can receive for your loved ones. So we're going to dive into this. There we go. Well, going the wrong way. Let's see. All right, we'll skip that, but we do a lot of just be sure the estate planning, you've got that set up, because it's a lot better for your loved ones not to inherit anything, but we can, in most cases, you can fix that down the road. Again, we talked about SSI and Medicaid and things of that nature, and just be aware of all of that. All right, Why do you need a will? Just be sure you have a will. In Texas, if you don't die without a will, then the state's going to tell you how your assets are distributed. And if you have a child with special needs or disability getting SSI and Medicaid, then they can't inherit anything. So I do a lot of what we call in Texas airships and administrations, and we do quite a few when the parents pass away and leave their loved one on means dependent government benefits, whatever they may be in your state. Then they can't inherit anything over $2,000. So in Texas, we end up putting that in a special needs trust within the court system itself. And if it's over about 150,000, then the court's going to make a bank be the trustee, which you're going to end up paying money to the bank to look after your own money for your loved ones. So that's one good reason for all of you to get your will set up. You can have a special needs trust on the outside, which is what I have. And then you can also have a contingent trust within your will that stays dormant until both parents pass away. And then their loved one that's on government benefits that can go to that special needs trust. But definitely ways to do that. We won't cover a lot of this because a lot has to do with Texas. We're a community property state, and that may not be the situation in your state. In Texas and in a lot of situations, you can have different types of wills. In Texas, you can have a photograph or handwritten will. And especially with loved ones with special needs or elderly people, you really want an attorney to do your will for you. And also, if you've got a blended family, I've got a son from a previous marriage, and if you're married to someone that already has children, in Texas, they're not going to inherit anything in your will if you're not the biological parent or have that in there. So just be aware with a blended family, if you want your wife's or spouse's kid to get anything of yours, be sure to put that in a will. And in Texas, if you come here from another state, then as long as your will is valid in another state, it's valid in Texas. And in most cases, that's the same with other states. Also, again, in Texas, if you die without a will, and you have guardianship or something off your loved one and you don't name the successor guardian, then the state's going to go down the list. They'll start with grandparents first being the guardian, then go to brothers and sisters, aunts and uncles. In my situation with our daughter, she's 32 now. One set of grandparents are better than the other in looking after her. So it may be that situation in your family. And just be aware of that. And in Texas, you can put this successor guardian in the will, or you can do a separate document. Definitely do that in the state that you're from. Trust, very helpful in either keeping assets out of probate, or in our situation, we have a special needs trust that everything's going to go to once my wife and I die. And basically, that shields that money from SSI and Medicaid looking at that. So very important to set that up. All right. Again, it helps manage assets. In some cases, a trust can lower taxes, shield assets from SSI, which is the main thing. And in some situations, I have clients, their kids are at group homes, or we have a place out here, Brookwood, that we have a lot of kids at and adults at, group home, huge group home community setting. And special needs trust cannot pay for food and lodging. That's what SSI is supposed to pay for. And what I tell my parents, and we have something in Texas called a state countrywide ABLE account that you can put money into also, that we use along with the special needs trust. The special needs trust, as I mentioned, cannot pay for food and lodging. If your kids grow up after age 18 and move to an apartment and they're still on means dependent government benefits, then The ABLE account may be something you want to put money into, and you can pay for their apartment and give them cash outright. In the special needs toolkit, it tells you what the special needs trust can and cannot do. So basically what we try to do with our families is understand the buckets. If they're getting means-dependent government benefits, SSI and Medicaid, be sure the money is in the right buckets, and the people that are looking over those buckets understand how those particular things can be spent on. So, because really the only reason a special needs trust is needed with your loved one is if you're getting means-dependent government benefits. There's different kinds of special needs trust. We have a third party which will be funded with all of my assets when we're gone. Normally, parents do not fund a third party trust until they pass away, because if you fund it ahead of time, then it's going to be taxed. The interest earned is going to be taxed at the highest tax bracket. So it's better just to do a fidelity type account and leave that account, the beneficiary is your special needs trust. In regards to fidelity accounts, whatever you want to call them, there's something called the Secure Act. And when you leave a special needs trust or a loved one is beneficiary with special needs or disabilities, then they can actually keep that money until they turn 70 before they have to do required minimum distribution. But if you give that to someone that doesn't have a disability, they're going to have a payout in 10 years. So I'm just kind of throwing out a lot of things to think about when you're doing this. As I mentioned, we have a third-party trust, which is third-party giving money to that trust. Then there's something called a first-party trust, which is money that's earned by your loved one, such as a court settlement or back SSI payments, although you have a year to spend that, or gifts that they may receive and they can put it in themselves. And then we mentioned the ABLE account. That's a state run, and each state has that. And that's in Texas, or you can put up to $19,000 a year in it. You can put $100,000 into it before SSI sees it. So that's another mechanism. We also have something called a Texas Pool Trust, and really that's somewhat similar to an ABLE account, although the Texas Pool Trust has first-party, third-party trust within it, and that's usually when you don't have any other family members around anymore, and you've got money for your loved one. No one's going to be around to look after it, and I have a few elderly clients that have put money into that when they didn't have any people to look after their loved one after they're gone. First party trust, again, that's money from your loved one that they own themselves. The problem with the first party trust and the ABLE account, the Texas Pool Trust account, is it has what we call Medicaid payback. And what that means is when your loved one passes away, then Medicaid can come back after those three accounts and recoup their money. The third party doesn't have that. So that's one good thing about third party trust. And the third party trust, you can put millions into it and your loved one can still get means dependent government benefits. How long that's going to continue, I'm not sure. It's a great situation. Again, third party trust, not subject to Medicaid payback. And that's what we will be giving all our assets to when my wife and I pass away. My parents gave my daughter some money when they passed, and that's the only money we have in it right now. But it's sitting out there in case it's needed. Special needs trust, you can't give cash, pay for food, or pay for rent with special needs trust. That's basically what SSI is for. And then in order to do that, then you can move money from your special needs trust to an ABLE account to take care of that. I know the first of the year, parents can pay for food if their child's on SSI and it's not means dependent. It's not considered in-kind support, and if you pay for food and lodging, it's in-kind support, and then you're deducted 1/3 of your SSI, at least in Texas anyway. So what we do with parents is we have a rental agreement with our daughter. She pays us a certain amount a month, and then she gets her full SSI payments. So in your state, be sure you're getting your full amount with SSI. Again, this is all in the Special Needs Trust is pretty universal, so it's in your booklet if you can look at it later. In Texas and in most states, except for a few that's 19, once your child turns 18, they're adults. In the eyes of the law, they function just like you and I without any disability. So just be aware of that. There's alternatives to guardianship, such as power of attorney and medical power of attorney, which y'all I'm sure are very aware of. But in Texas, they have to have the cognitive ability to understand what they're signing, legally and personally. So a lot of my kids have IDD, my daughter included, and so a power of attorney and medical power of attorney would not work, so we had to get guardianship. Because once they turn 18, as I mentioned, they're adults, and you've got to go through all that rigmarole in order for the parents to make legal and medical decisions for your loved one. In Texas and probably a lot of states, guardianship is called conservatory. In your state, in Texas, there's guardianship of the person. That's what we have on our daughter. I say when our daughter, when I'm at a resource fair and I'm telling people my daughter, then my wife nudges me and say, I think I had something to do with it. So I'm very cognizant of that term. Most of these kids turning 18 is guardianship of the person. Guardianship of the state is mostly with elderly people that have a house and accounts and things like that. And then in that situation, you have guardianship of the person in the state. And then there's temporary guardianships. I'm doing one now with an elderly parent that's in hospice, and he didn't have a medical power of attorney, so the daughter's going through guardianship in order to take care of him. Full versus partial. Again, 13 years ago, whatever we did full on my daughter, if I was doing it today, it'd probably be partial. Full is basically taking away all their rights. Again, you're not, it's kind of hard saying you're going to take away the rights of your loved one, but basically you're protecting them from the real world if they're not able to function entirely. Most of the guardianships nowadays, I take away, they're partial, and the minimum we take away are business and financial decisions, medical decisions, and the right to pick their own domicile. And the first two are very obvious on what they can and cannot do. I usually tell parents to take away the right to pick the domicile. Because even though you have guardianship, your kids can go see whoever they want to or run off. And if you have the right, take away the right to pick their domicile, then you can have, in Texas anyway, you can have a constable go pick them up. Where if they have a right to pick their domicile, then you would have to prove to a constable that they're in danger to themselves or someone else. So it just makes it a lot easier on parents, not that your kid's going to run off, but even with guardianship, they have a right to see who they want to. Have a lot of clients with mental issues, and just be aware that you can't, even with guardianship, you can't force your child to take meds. And some things like that. So just be aware that they do have a lot of rights left, even though even though there may be a full guardianship. In Texas, and probably in your states too, almost anyone can be guardian of your loved one. The main thing, don't have a felony in your past. I've had a number of clients that 20 years ago had a drug conviction, and we usually just write a letter to the judge saying in the last 20 years we've been a model citizen and parent, and that usually works. If you've had in Texas anyway, if you've had a DWI in the past 3 years, forget about being guardian of your loved one. The judge is not going to allow that. I was the attorney ad litem, which is the attorney that represents your child in court, and then of course the parents will have an attorney also. And one of the parents forgot to tell his attorney that he had a DWI 3 years ago, and the judge wouldn't let him be guardian. He said, "Come back in 5 years and I'll consider it." Because what happens is that these judges and counties are responsible for your loved one. So the judge is not going to take any chance that you may be driving around intoxicated with your loved one in a car. So I honestly say, and I do all the surrounding counties here in Texas, well, in Houston area. And I will say all of the probate attorneys, which in Texas, what you do guardianship if parents still alive. And they all really look after the best interest of your child, especially in divorce cases and stuff. Guardianship steps here, we can file for guardianship 6 months prior to 18th birthday. There are in Harris County, you can actually have a hearing prior to the 18th birthday, and then the judge will wait until your child is 18 to sign the order. The other counties will not do that. So what we try to tell them, what I tell my parents is call me at 8 months prior to the 18th birthday, and let's start the system going. And then at 6 months, we can file for guardianship, and then as soon after the 18th birthday, we can get a hearing. But what we try to do is get everything done and get a hearing date where we can get things going as soon after they turn 18. As mentioned, guardianship of the person is really what you're doing for your loved ones now. It's just once they turn 18, you've got to do something where you can continue that. And most of my guardianships are guardianships of the person. Guardianship of the estate. Really, I've never had an 18-year-old. Well, I've had one that had a underage minor account that their grandparents had set up, and they didn't want to move it. In Texas, the loved one can have $20,000 in assets, and you can still have guardianship of the person. If it goes past that amount, which I normally tell parents is move it to a special needs trust before they turn 18, where we don't have to go through guardianship of the state, which is a lot more steps, and then you have to hire an attorney every year to file a financial report. In Texas and probably most states, you just file an annual report. Well, I won't say most states, file an annual report each year with the county and pay between $20 and $22, and you get your 5 guardianship letters. We have to renew them every year in Texas. But that's really what it's going to cost you in Texas to do that. And I do quite a bit. I'm not sure why people want to move to Texas with a loved one with disability, but I've done quite a few in the past couple of years of transfers from other states here. So that can be done if your guardianship is in another state. We just transfer it here. It's about half the steps that you normally go through for regular guardianship. And in Texas, we're by law, we're supposed to look at the least restrictive means to guardianship, such as power of attorney, medical power of attorney, and HIPAA release. Again, in Texas, your loved one has to have the cognitive ability to understand those, or otherwise the only thing is guardianship. We also have something in Texas, supported decision-making agreement, and that's an agreement parents can use in the ARG meetings when their loved one turns 18 and they don't have guardianship, or if you can't afford guardianship, then that's in between power of attorney, medical power of attorney, and regular guardianship. What that document does allow the parents to get into the meetings and explain to their loved one what the meeting's about. And then we talked about the ABLE Act, statutory power of attorney again. Hopefully all of you have that. I will say if you're lucky enough to have your parents still living, be sure you're on their power of attorney and medical power of attorney as a successor agent. And tell them that you won't get into their business unless they're incapacitated. Luckily, my parents, I was on everything they had, but you see a lot of the older parents put each other on And what happens, one gets dementia, another has a stroke. And then in Texas, the only thing that you can do is get guardianship of your parents. And that's just crazy to have to go through. And I'm doing one of those now. Again, medical power of attorney, y'all all of it probably very familiar with that. But, even if you've got, I do a lot of these with typical kids going off to college. Once in Texas, once they turn 18, they're adults. And if you're going to UT or going to Texas A&M and your child has an accident and in the hospital, you really can't call the hospital and check on them unless you have a medical power of attorney. So just be aware of that with your typical kids. Again, in Texas, we won't go over this since most of y'all are not in Texas, but this is, as I mentioned, just an agreement that is in between that helps parents at least get into meetings with them. It's supposed to help you get into the doctor's office and things like that. I don't do these in my practice. You can download them from the ARC of Texas website or some of the other websites. And I haven't had any parents complain that it didn't work, but it should allow you to get into meetings with your loved ones. ABLE Act, again, a good way to put money in. I normally tell parents they don't need that unless they need to pay for a group home or pay for an apartment and stuff. And the main reason, you can put money in a third-party trust, and then if you ever need the ABLE Act, you can move money over. In Texas, we're a bit late in getting a debit card, but other states have debit cards. Texas does too, so that can be used to spend that money. But the ABLE Act, they will invest the money for you. Right now, it's a maximum $19,000 a year you put into it, which is the gift limit, and then you can put up to $100,000 in it, and then $500,000 a lifetime. So it has its uses for sure, but again, it's subject to Medicaid payback. So normally, what I tell parents to do is, if you know your monthly income that you need to be spending out of this, only put that in there and don't put a lot of money into it. We'll keep out of that. Y'all are not need to talk about the Texas Master Pool Trust, but if you've got a pool trust in your state, you can look into it. There's something called a letter of intent. We know our kids better than anybody. So if something happens to my wife and I, my mother-in-law will take over his guardianship, and then I've got a 37-year-old son that will take over guardianship of his half-sister later in life. But he lives back in Alabama, so he only sees her a couple of times a year and really doesn't know everything that she does. But we sell it in our practice, but then you can just do it, put together a loose leaf notebook with everything about your loved one, because if something happens to you, the person that's going to take over needs to do this. Ours is about 75 typewritten pages and a booklet. We used to update it every 6 months, now about every 1 to 2 years, but it has everything about our daughter. She has 4 part-time jobs and works 6 days a week. So she's got supervisors, where she goes, doctors, as y'all probably well know, and everything else, what she likes to do when she gets up in the morning, this, that, and the other. So we have all of that out. So my son, if he has to take over, can read this in about 45 minutes to an hour and know everything about his sister that he needs to know and can jump in right away. But, we take things for granted, just the small things that our loved ones does. But if something happens to us, which we know our kids better than anybody, we need to be aware that somebody that's going to take over, God forbid, that knows all about our loved ones. So definitely put together something for your loved one with this. And that's just other things in that letter of intent. SSI and Medicaid, hopefully, if your kids are 18 or above, they're getting that. In Texas, prior to age 18, it's based on the parent's income. Once they turn 18, it's based on how their disability affects gainful employment. So just be aware of that. And again, you can only have $2,000 in assets. I hear that's being raised, which is good. And with that, and all of this is in the booklet I give out. In Texas, here are our main waiver programs. We have just, after 17 years, my daughter just got HCS, so we're very pleased with that. And I'll tell you something that my family did here shortly on trying to help other parents in the state of Texas. But you can really go through there and Google that to find out what you're getting. About the only one, the MDCP, Medically Dependent Children Program, that's about the only one, maybe one other that you can get prior to age 18, and it doesn't look at parents' income. Again, you can look at that. Again, all these numbers are for Texas, so I apologize for that. Again, if you're in Texas, that's who, in the Houston area, that's who you should call for this. Other possible problems you should think about. Parents set up a 529 college plan. If your child's not going to go to college, that can go to other siblings or to cousins or something, or they can roll it over to an ABLE account. They can do that. UTMA account in Texas, again, that's another account a lot of grandparents set up. That money transfers to a child at age 21. So in guardianships, I know some counties will not allow that, and we have to move into a third-party trust. Again, if a parent in Texas dies without a will and they leave a life insurance policy to a minor or to a loved one with special needs, then we have to fix that in probate court. I had one gentleman that died with a will, and he left $500,000 to his 7-year-old son instead of going to a trust. And they were expats here in Texas. The dad worked for an oil company. And so mom had to get guardianship of the estate of her son in order to get access to that money. What insurance companies will tell you if a minor inherits a life insurance or a retirement fund is that there's 3 things that can happen. At age 18, that young man would have gotten $500,000, or we could have put it into a UTMA account and he would have gotten $500,000 at age 21, or we went and got guardianship of the estate, mom did, of her son, where she could get that money now. So just be aware, it's a lot easier to set up in your will or have a successor beneficiary on your retirement or life insurance instead of your child. And so just be aware of that. I'm not sure how other states handle minor children inherit anything, but in Texas, you really need to do something prior to age 18. Okay, this is something I'm very proud of. That's our daughter, 32 years old, with her bunny Emma, and she's testifying in front of the legislative committee this past, I believe it was in February. 2 years ago, we introduced a bill into the legislature with the help of the ARC of Texas. My wife, we were thinking in Texas, school systems are not supposed to tell the parents about the local litters or the Medicaid waiver list by law until age 14. In Texas, they go through the adult transition program in schools. I'm not sure how the other states do it. Again, Texas has a huge waiting list, where if other states it may be 6 months, big difference. But in Texas, there's a long waiting list. So my wife came up with the idea, well, why aren't we telling the parents about the letters and the Medicaid waiver programs once they get into the school system and their child's diagnosed with a disability? 2 years ago, we have a session every 2 years in Texas. It's not every year. So the first time we tried it 2 years ago, we got through the House. We had a high bill number. It got stalled in the Senate, and so it was not passed. And we were letting the Arc of Texas do all of the lobbying and things like that. This year, we got more involved. My family did. My wife, I was tagging along. And we started going in January every 2 weeks and meeting with representatives and senators and telling them about the bill, non-partisan bill, no physical note. And so what we found out about from the previous session 2 years ago is that a lot of times in the first vote, it was a nonpartisan vote. And then toward the end, it got partisan vote because no one knew what the bill was about. And and then this year we started going to the representatives, we went to the ones that voted no on the second and third vote. And we found out that when we told them about the act, they said, this is a no-brainer. Why would you vote against that? Of course, we didn't say, well, you voted against it. So what we found out is that you have to go and tell them what these bills are about. We brought Caitlin. We had one senator that we had a Zoom call with the first section, and he actually had the audacity to on Zoom with my daughter there, is that she doesn't look disabled. And, so we made a point to go back to that senator and have our daughter with us. And he ended up being a co-sponsor of the bill. So what you have to do, and I was answering your question, sir, you had how you get more involved, is that these representatives think we're statistics. And you have to put your loved one in front of them. And you get a 32-year-old coming in there with her bunny Emma, and it's a total different situation. And we end up getting through the legislature with almost no negative votes, and then got through the Senate and got it passed. But now parents all over Texas, when their loved one has the first ARG meeting, they're going to be told about the Medicaid waiver program and all that. So that's going to, in some situations, that's 10 years early. So that will help all of these families get on the waiver list a lot sooner, because our 15 to 17 year waiting period is not going to change in Texas. Just be aware that that's the way it is here. That's another thing we can work on later. So just to let you know, a family can make a difference. We went with Arc of Texas and they helped us, but we didn't know what we were doing 2 years ago. And now, it was real funny. I'm sorry, I get on this and I get real emotional about it, but, we were sitting in, waiting for our next meeting at the Capitol, and you have these representatives stop what they're doing and came over and give Caitlin a hug. It made a huge difference in showing these representatives how our loved one, who they are, how they're doing it. And that's what it takes. You can't let someone else do it for you. Take the bull by the horn, as they say. You may not get lucky as we did. We're very lucky, and but it may take 4 or 5 years, but you can make a difference for your loved one, depending on which way you want to go. But I had to do my spill on that. I know a lot of y'all not from Texas, but if you want to see something that you're going to cry, go to my website. My wife's got some of the testimony on that, and I tear up every time I see it, and absolutely amazing. And that was her first time testifying. She testified in the Senate and the House, and made a huge difference. I won't keep going on this, but anyway. But thank you very much. I'm fixing to head out here shortly and go. We're doing a resource fair in Aldine School District, and that's what we try to do, is pass out as much information as possible to these families and go from there. But I know y'all aren't from Texas, most of you, but if you have any general questions, I'll be glad to answer them for you.
Thanks so much. Thanks so much, Mr. Handley, and thanks also for sharing about Caitlin's story. That's really inspirational. I just have a sort of general logistical question. So, if we're thinking about more comprehensive sort of future planning and estate planning and trusts and wills, do you have a recommendation? There's a lot of good or seemingly good, kind of comprehensive websites like Trust and Will. There's obviously attorneys that specialize in estate planning, and then attorneys like yourself with even more specialization, like special needs trusts and special needs attorneys. If we're looking to do like really comprehensive thinking about, property, financial investment, trusts, wills, all of that, would you recommend going as specific as seeking out a special needs attorney or someone who kind of does more general estate planning?
There's a number of National Association of Elder Law Attorneys. A lot of those have special needs work in it, uh, and you can Google that. I'd Google special needs attorneys and see what. Also, with financial planners, be sure that your financial planner either has a loved one with special needs or has a family member. There is a certification for special needs planning that some financial planners have. Uh, if you email me, I can figure out that acronym for that. I've got two that I use here in town. One has that uh, certification, and the other has a special needs child. So, but that's really and you on your financial planners, you can go with a big firm, which is fine, but to be sure they have I know Mutual Life has a special needs trust and planning group. So just ask them what it's going to take, and they can give you an idea about your investments, knowing that your loved one's going to need a lot of money after you're gone. So definitely start now and set things up. It's a lot easier to set it up now, even though a lot of us don't want to talk about wills and dying and things, but we're going to be gone one day. So set it up where whoever's taken over for your loved one has an easy path to go forward. A lot of times, families may appoint a guardian, one person in the family, and then have another family as a trustee of the special needs trust. Because that guardian is going to have their hands full with your loved one. And it may be better if you've got a family member that has some financial background, which is not needed, but another person being the trustee. So things like that you can do. Mm-hmm.
Yeah, do you generally recommend splitting up like medical power of attorney and then financial or is it better to just sort of put all your eggs in one basket?
With me, of course, my wife's my agent, then my elder son, my only son is the successor agent. So, you put, different, at least two or three, where if the next in line, something happens to them, that they can take over.
Thank you so much.
Um, Broad question, and I'm not sure if it differs from state to state, but if you and the other biological parent are not together, can you set it up so that that other biological parent, whether they're a co-guardian or not, does not have access to the money that you saved for your child?
Yeah, we do that quite often. You can only have one first party trust, but you can have as many third party special needs trusts. So a lot of times grandparents will set up their one or divorced families because what's going to happen, you're going to have beneficiaries after your loved ones passes. So you want to keep that money that you put into on your side of the family, and he would need to set up one for his side of the family, because what you don't want to do, whether you're talk a lot with your ex or not, is that if they set up one themselves, they need to understand what they can pay for and what you don't want to pay for, because what you don't want to do is the other side of the family has a special needs trust and start paying for something that they're not supposed to, and then you lose your SSI or Medicaid benefits. So, and then with them dying without a will. Uh, be sure if they do pass away, whoever's doing their probate, you need to tell that attorney that your loved one can't inherit anything, and they need to fix it in probate court with that. But yes,
between the two parents
absolutely.
to make
The trustees collaborate between the two. But yeah, you can separate your assets from your ex's assets, or the yep.
A hard topic for a lot of families. I know for my husband and I, it's something we still need to do, and he's 14. So I thank you for coming, for sharing this information. I know it's difficult to hear as parents, but we thought it would be very beneficial for all of you to hear, even to just start thinking about the future so that our kids are taken care of. So thank you for that knowledge. Looks like we have one more question over here.
I just want to, I'm very fortunate. I'm on my second wife, but this one's 35 years. So, I divorced my first due to some other issues. But, with special needs kids, it's very hard for parents to stay together. I mean, the divorce rate. So I compliment all of y'all regardless of what situation you're in. I know with my wife, I agree. We agree on everything. She's the researcher. And she goes everything, and I'm being a geologist. I said, "Well, show me what you found," and it sounds good. I'm all for it. So I compliment y'all with any of that.
My question is on the assisted decision making. So right now I'm doing that for my daughter. I know her medical team has asked me several times, "Are you gonna get guardianship for her?" And there's things with the guardianship that I'm uncertain about because, like, down the road, I'm not sure if she's going to want to do some of those things. Is there paperwork that...
Court of decision making is only in Texas. So you would have to ask somebody if you're not from Texas about that.
Arizona too, so that's why it's in Arizona too, so that's what I'm doing, but I'm not sure if I'm supposed to have paperwork for it so that...
What will happen in Texas, again, I'm not going to say anything about Arizona. You would have to give a copy of that to the ARG meeting or to your doctor's office. And in Texas, it only allows you to... Now, if your child is under 18, you don't need one. It's only once they turn 18. And what that document does in Texas is it allows you to explain to your loved one what the meeting's about. But your loved one over the age of 18 has to make the decision. So basically all that does is to get you into the meetings with your loved one, and the school and the doctor can't kick you out. So, with that.
There is paperwork for it.
You need to show your doctor or your ARG meetings that you have that paperwork signed by your loved one. And in Texas, your loved one can sign it whether they know what they're signing or not. In Texas, it's a gray area where with the power of attorneys and stuff, by law, they have to know what they're signing. With this document, it's really the legislature had a good idea. Let's make it gray where anyone can use it to get by between the other two.
Hi, really fast question. I'm from California, and a lot of my friends, or what I hear, I do a lot of research and diving in, is by 16 and a half kind of seems to be a marker, a year that everyone says you got to get we call it conservatorship in California, get that ready. Recently, a girlfriend of mine started it a little too late, and she did it on her own. She didn't hire an attorney, but she started doing the paperwork when her daughter was 17 and a half, and the courts told her, it's a myth. They keep saying 16 and a half, you need to get on it, but we get paperwork that's filed too soon, and then you got to redo it at 18. Is this something you've heard of?
Yeah, I mean, we have school systems telling people come to them at age 14. And I tell parents to say, you've got too much to worry about. In Texas, 18, 8 months prior to 18, come to me. I'll tell you about it. But we can't even file until 6 months prior to age 18. So in most most places, I think California is still 18 as an adult. So I'm not sure, probably the earliest you could file there's, a few months ahead of time, because it defeats the purpose by filing it at age 18 or after. Of course, you can get guardianship anytime at any age. But, I would call the probate court or whatever, Supreme Court in California, and say, okay, I'm thinking about, you can do it online anyway, and find out how soon can you file. In Texas, you have to have a lawyer. So not sure if you can do it yourself in California, but yeah, until they turn 18 or become an adult, you don't need anything. But, luckily we can in Texas file 6 months ahead of time and get everything done prior to age 18. Take it off my list. Yeah, absolutely.
Oh, one right here. This will be our last question.
So if we did set up guardianship for our daughter, and I've been watching Love on the Spectrum. If y'all haven't seen it, it is the best show ever. But what if she did find someone and decided to get married? Would she still be able to do that if we had guardianship of her?
You can give her the right to marry. You don't have to take that away from you. But yeah, if you do take it, like in our situation, we have full guardianship. Of course, my daughter will never marry. But, if they are starting to be high functioning and can marry, if you think that could be in the future, I wouldn't take that away from them, because the good thing about Texas, you can always go back and give their rights back to them. I'm doing one where we're giving full rights back, and I've got one where we're giving 2 rights back to the child. Unfortunately, you have to go through the whole process again. But
so it's not like permanent final be-all?
No. In Texas, guardianship is not permanent. I can honestly say I've been in one situation where we're giving all the rights back, and I've got another doing it myself. I tell parents, a lot of these kids aren't mature at age 18. So, we take away the minimum, and then in 4 or 5 years, we can go back if they've matured and give something back to them. And then you can even have we have something called a physician certificate that has to be filed in the court, which tells the court how the disability affects everyday life. And the physician can actually put into that, well, we've got a partial guardianship and we want to be reevaluated in 4 or 5 years. So, and the court will make you reevaluate your loved one. So guardianship is very open. You can take and give, and then you can always give it all back to your loved one. So,
great. Thank you.
Yeah.
Please give him a round of
Applause. Thank you for all of your information.